The question at hand involves a private limited company, Roda, a lorry transport business aimed at providing services to the manufacturing industry. This type of company is one that is a body that has a legal entity separate from members or the founder, as stipulated in Section 20, subsection 1 of the Companies Act 2016. This principle of separate legal entity was also upheld by the House of Lords in the 1897 case of Solomon and Solomon. The company falls under Section 10, subsection 1, subsection A as being limited by shares, which can be assumed by the fact the total shares of the company are held by 3 individuals, with Rahman owning 60% of the Companies Act, of the company's shares, and 40% being jointly held by Razak and Nadia. Shareholders' liability is limited to the amount of shares owned or held by the members only, and purchase of shares is only possible if it is offered to selected persons. Disagreement and altercation during a board meeting led to Razak and Nadia continuing running the company together without Rahman, with him also ceasing to attend board meetings, but continued to receive a salary. The company's Articles of Association, which is not only a contract between a company and its members, but it also contains details of the structure of a company, appoints Rahman as a director with a 200,000 ringgit a year salary, and under Section 202, subsection 1 of the Act, he is seen as the first director. Section 211 imposes that the affairs of a company shall be managed by the board, of which Rahman is part of in this case. Due to his absence, Razak unlawfully stops the payment of salary to Rahman under Section 230, subsection 1, as no shareholder resolution was passed to amend Rahman's remuneration. Rahman wants to attend the next board meeting. However, Razak and Nadia do not want him back and want to manage the company without him. Under Section 31, subsection 2, Rahman, Razak, and Nadia have the rights, powers, duties, and obligations set out in the Company Act and are bound by the Articles of Association under Section 3.3. So in this presentation, we shall look at tackling the following issues. Is there oppression against Rahman under Section 346 of the Companies Act? Can Rahman apply for leave of court and initiate derivative proceedings? Does Rahman's conduct have any gravity on his legal remedies and the remedies available for Rahman?
The first issue to look at is whether or not has Rahman been prejudiced and oppressed in an unfair manner, despite him being the majority owner in Roda Sendiri Berhad. This will be divided into 2 parts to analyze was Rahman's exclusion from managing the company's activity and participation in the company's board meeting, as well as the withholding of the salary payment to Rahman, which goes against the contract, constitute an oppression against the majority owner of the Roda Sendiri Berhad. According to Section 346 of the Companies Act 2016, it allows any members of a company to seek relief provided that the company affairs are conducted in a manner which is of an oppressive and prejudiced manner against their interests, as perceived in the case of Pan Pacific Construction Holdings Sendirian Berhad against Nanju Key Corporation, Malaysia, Sendirian Berhad, and another. The court gave a conclusive statement as to the critical test to show oppression is whether or not there's been commercial unfairness. The term commercial unfairness must go beyond that of a mere corporate mismanagement, and it must exhibit oppressive conduct, such as the misuse of authoritative power for unjust motives. In this instance, Rahman can be said to have unfairly oppressed, as he was not given any right in how the company functions as a shareholder of the company, since the 2 shareholders were actively trying to exclude him from the day-to-day function of Roda Sendirian Berhad, despite him being the majority shareholder. The case of Enkek V against SimCity Technology Limited, which has demonstrated that oppression may take its effect on majority and minority shareholders. And the power to seek relief is not just limited to the minority owners. Similarly, in the case of Richard Martin Parkinson against Eurofinance Group Limited and others, the minority, which being Parkinson, was impeding the majority by actively excluding the majority owner through the means of removing him from the management and both the parent and subsidiary level and sabotaging his position on the board. Applying these legal principles into the current scenario, Rahman has said to hold 60% of the company shares and expressly appointed as a director. which means this would have given him the locus standi to initiate an action. Despite his shares in Roda Roda Sendirian Berhad and position as one of the directors, he has been excluded from attending board meetings since the incident in August 2022. As perceived in the case of Parkinson, the minority orchestrated the exclusion of the majority owner on zero lawful basis. And the parallels in this instance shows Razak and Nadia cut the salary and blocks Rahman on returning to the company illustrate that he had indeed faced oppression from the minority shareholders within the company. Furthermore, there was not any formal board resolution to remove him from his position as a director, and yet Razak and Nadia are operating the company without him. And his wish to return faced unjust oppression from them. The extent of exclusion shows that there's been a denial of Rahman's legitimate expectation to partake in the company's affairs and exercise his power as one of the members sitting on the board of directors. From the conduct of the minority owners, it has been shown that there's a shift of power from the majority to the minority, which the court held as oppressive in the case of HR Hammer Limited. In conclusion, Rahman has a strong claim under Sections 246 of the Companies Act 2016, and for the fact that he was unfairly excluded from the management of Roda Roda Sendirian Berhad, despite him owning the majority of the company shares and his directorship. And such exclusion infringes commercial fairness and as well as disregarding his legitimate expectations of the company. Thank you.
Next, I will talk about the issue of withholding salary. The UK common law position outlined that a company's constitution consists of articles of association and the memorandum of association. An article of association contains details of the structure of a company, which then binds the internal mechanisms of the company. Essentially, it's a set of rules that govern shareholders and the company as a whole. The Malaysian position was previously under the Companies Act 1965, which then followed the UK position and further encapsulated that the article of association is the regulation of the internal management of the company's affairs. You can either draft your own article of association or use the one given in Table A, which is then binding. However, further changes were made, and now under the current Companies Act 2016, it is the company's constitution which consists of the article of association that deals with the internal regulations of the company, such as salary. Section 31, subsection 2 and 3 of the Companies Act 2016 both show that whether or not a company makes itself a constitution, Raza as the shareholder has certain obligations and duties to follow and cannot act on his own. Section 31 provides that the Articles of Association can be altered and amended through the passing of a special resolution. To see whether Rahman can rely on Section 346 of the Companies Act 2016, there has to be oppression. Following the Recom Taiswam Mill case, in order to establish oppression, there must be a visible departure from the standard of fair dealing. Suddenly stopping Rahman's salary can be enough to amount to this visible departure, and therefore it will succeed as an oppression. The further cases to settle this is the Pan-Pacific construction case, where the Rahman as the shareholder needs to prove that he was treated in an unjust and unfair manner. Rahman clearly did not want to let go of the company, as he states he intends to make one last effort. Therefore, to just cut off his salary can amount to an acting in an unjust and unfair manner. Further situations of oppression can be seen following the Edmund Charles Lindbergh case, where following this case, Raza as the shareholder can be seen to have exceeded his power and can be said to have an ulterior motive. Again, Rahman intended to make one last effort and is therefore showing that he want to let go of the company. Instead of following the legal proceedings, Raza just cut off his salary, which can amount to oppression. As Michael Duffy further says in his article, shareholders are held to a legitimate or reasonable expectation. Courts then use these expectations when establishing an objective basis for fairness, though the use of the phrase fair legitimate expectation is somewhat contested. However, in this case, it is clear that the salary was expected to be given to Rahman as per what was outlined in the Articles of Association. Ultimately, there has been a serious breach of the article, and the only way Raza could have legally stopped the payments would have been to alter the Article of Association itself. There is no indication or evidence of this based on the facts. Therefore, Raza will fail of withholding the salary, and this can amount to oppression, which Rahman can claim.
We now move on to discuss whether Rahman can initiate derivative proceedings under the present circumstances. In company law, a company is treated as a separate legal entity from its shareholders and directors. As a legal person, it has its own rights and liabilities. When a wrong is done to a company, it is the company itself that has the right to sue. However, difficulties arise when those in control of the company, such as directors or majority shareholders, are the ones that committing the wrongdoing. In such cases, the company may be unwilling or unable to take legal actions against them. To address this, the Companies Act 2016 provides a statutory mechanism known as the derivative actions. A derivative actions allows a shareholder or director to initiate, intervene in, or defend proceedings on behalf of the company when the company is unable or unwilling to do so. This statutory remedy is governed by Section 345 to 350. In Rahman's situation, he may consider bringing a derivative actions against Razak and Nadia. Although he owns 60% of the shares and would usually be seen as a controlling shareholder, his exclusion from management and alleged mismanagement by Razak and Nadia puts him in a position akin to a minority or aggrieved party, since the company is now run by Razak and Nadia without his involvement, and they have allegedly made poor business decisions that harm the company. Rahman could argue that they breached their director duties by failing to act in the company's best interest. If no steps are taken to protect or recover company assets, Rahman may seek leave under Section 347 to initiate the action in the company's name. Under Section 345, a complainant includes a current members, a former members in some cases, a director, and a person entitled to be registered as a member. This ensures not only shareholders but also directors with a genuine interest can initiate proceedings. In Rahman's case, he qualified both as a shareholder and a director, placing him within the statutory definitions. The next issue is whether Rahman, despite being a majority shareholder, can bring a derivative actions. In United Engineering Malaysia Berhad and Seo Boon Cheng and another, the court held that a majority shareholder who holds over 51% and has effective control cannot bring a derivative actions, as the company would be the proper plaintiff. The rationale is that the shareholder could use their voting power to direct the company to sue. Similarly, in Pointer Heavens and Berhad and Ho Hub Constructions Company Berhad, the Court of Appeal clarified that the key factors is not merely shareholding, but whether the complainant exercises control over the general meeting and can remove directors. Where such control exists, the proper course is to use internal mechanism rather than a derivative actions. Applying this principle, although Rahman holds 60% of Roda Sdn Berhad's share, it is unclear whether he is currently exercising control. He has been excluded from management by Razak and Nadia, but whether he retains access to board meeting or voting rights is not specified. Whether Rahman can remove the directors or influence decisions depends not only on shareholding but also on the company's constitutions, which govern board compositions and directors removal. If Rahman still have practical control under sections 206, derivative actions may not be suitable. However, if he is actively prevented from exercising his rights, and if Razak and Nadia control both the board and corporate decisions, the court may find the company under wrongdoers' control, justifying leave for a derivative actions. The court must assess Rahman's levels of control based on facts and the company constitutions before deciding who is the proper plaintiff. Before a derivative actions can begin, Section 348 sub 2 requires the complainant to give 30 days written notice to the company directors. This notice must outline the alleged wrongdoing, the reasons for the actions, and the relief sought. The purpose is to allow the board a reasonable opportunity to consider the allegations and decide whether the company itself should act. If the board takes no steps during the notice period, the complainant may apply for leave. While the notice period is mandatory, the court may allow a shorter durations where urgent circumstances exist. For instance, in the case of Ng Hoi Kiong and Chua Chun Yang and others, the High Court permitted a notice given only 9 days earlier due to the urgency of defending and ongoing actions. In Rahman's case, he must clearly outline the exclusion from management, the alleged mismanagement, and the negative impact on the company performance.
Now, moving on to how Rahman can apply for leave from the court. Under Section 348, subsection 4 of the Companies Act, there's 2 requirements that must be met for leave to be granted to bring a derivative action. First, the complainant must act in good faith. Second, the proposed action must appear to be in the best interest of the company. Let's start with the first requirement, good faith. Good faith means there must be an honest belief that the claim is legitimate. It should be brought to address real misconduct and not out of personal grudges or collateral motive. A key example is the Singapore case of Ang Thiam Sui and Low Hian Cho. So in this case, the court dismissed the application because it was motivated by spite and rivalry and not a true desire to protect the company. So although this is a Singapore case, Malaysian courts adopts a similar approach, so by ensuring that derivative action serve corporate interests and not personal agendas. So how does this apply to Rahman's case? Rahman must show that he is not just trying to regain control or retaliate against Razak and Nadia, and instead he has to prove that he is addressing legitimate concerns like the company's declining performance and possible breaches of fiduciary duty. But here's the challenge. The breakdown in the relationship started after Rahman physically assaulted Razak and was fined for it. So because of this, Razak and Nadia may argue that Rahman's motives are personal or retaliatory. So how can Rahman respond? He can argue that despite the personal conflict, his main concern is the company's poor performance and also being excluded from management. So by pointing to these specific examples of mismanagement, he can show that his aim is to protect the companies but not settle personal scores. So this strengthens his case that he is acting in good faith as required under Section 348 and subsection 4. Let's now turn to the second requirement under Section 348 subsection 4, that the action must be in the best interest of the company. The court applies an objective test here. Would an intelligent and honest director acting reasonably believe that pursuing the legal action would benefit the company? So we see this clearly in the case law in Abdul Rahman bin Sulaiman and Farida binti Muhammad Lazim. The Court of Appeal granted leave for a derivative action because it could potentially recover 12 million in interest income for the company. The court held that such a recovery clearly served the company's financial interests, and so the requirements were satisfied. Applying this to Rahman's situation, Rahman can argue that if Razak and Nadia are allowed to continue managing the companies without accountability, it could result in further financial losses and a decline in shareholder value. So this would justify court intervention not for Rahman's personal gain but for the long-term protecting of the company. According to Professor Aiman Naima Muhammad Sulaiman, he stated that the statutory framework provides consistency and transparency. The leave requirements work as a gatekeeping tool. It helps prevent abuse but also empowers shareholders to step in when misconduct or management fails. So in this case, Rahman's exclusion from management and the company's deteriorating performance are exactly the kind of circumstances the derivative action is meant to address. Apart from good faith and the company's best interest, court also look at other surrounding factors when deciding whether to grant a leave. So this includes the company's financial positions, the conduct of the directors, and also whether the applicant has exhausted internal remedies. But here's an important exception. If the complainant is excluded from management, or if the alleged wrongdoers control the board, the courts may accept that internal remedies are effectively unavailable. In Rahman's case, if he can show that he has been denied access to board functions and that no corrective actions has been taken despite the company's declining performance, this could give the court a credible reason to intervene. And it's also important to remember that at this stage, the court doesn't require full proof of the claim. What matters is that there's a legitimate and arguable case is enough to justify judicial intervention through a derivative action.
All things considered, Rahman is a 60% majority shareholder and a director who is contractually entitled to run Roda has been oppressed under Section 346 of the Companies Act. The denial of having him attend board meetings and the unilateral decision to withhold the salary are contraventions of his legitimate expectations and commercial unfairness as affirmed in cases as Pan Pacific Construction and Re-H. Harmer. In this regard, Rahman can pursue remedies that include reinstatement in the management, compensation of withheld salary, or a buyout order in case a deadlock is beyond redemption. Moreover, in the event that during the process of examining the company records under Section 350, if the mismanagement by Razak and Nadia has negatively affected the company, Rahman can institute a derivative action under Section 347 by showing good faith and the best interest of the company. Once leave is granted, Rahman will be in a position to recover losses incurred due to mismanagement by Razak and Nadia on behalf of the company. It is suggested, however, that a lawsuit should be one of the last resorts, as mediation may still settle this deadlock. Ultimately, the law supports the case of Rahman, and judicial proceedings of cases such as TO and NG should show that the court has flexible powers to formulate the derivative proceedings to suit the necessity of justice and to the nature of the case. His prior assault on Razak, on the other hand, can be seen as a weakening factor in his case, should it be considered as a disruptive behavior.